appealing the matter of the HHJ.
Yes, Mr. Llewellyn.
May it please the court, I appear on behalf of the appellant and my learned friend, Miss Leah appears
Yes.
on behalf of the respondent local authority. The attendance of the counsel for the children through their guardian was dispensed with, my lord, through correspondence from Lord Justice Macur on the basis that the guardian's position reflected that of the local authority.
Very good. Well, we've got a skeleton from them.
Yes,
on behalf
indeed.
Of the guardian.
That's right. I should say as well that the appellant was granted permission not to attend on the basis that she had care of the children. To make matters clear, I appeared in the court below. My learned friend from the local authority did not, nor did counsel for the children through their guardian, who was authored the skeleton.
Good. Well, you can assume that we've read everything in the bundle. I, for some reason, didn't get a copy of the authority's bundle, so I've now been sent one together, so I'll be ferreting in that.
Very sorry.
But we're up to speed, as it were, on the case and the issues.
Yes. Subject to my lord's and my lady's views, if I can indicate now the structure I intend to adopt to deal with the issues.
Yes.
First, I have two brief points on the authorities, and if I may, that the guidance that the court has before it from the Public Law Working Group. And then I intend to focus my submissions on the first ground, and specifically why the sharing of parental responsibility was not necessary in this case.
Mr. Llewellyn, I wonder if I could just ask before we start a matter of housekeeping. The Public Law Group Working Party, the extracts of which appear in the authorities bundle, contain reference to the Welsh statutory instrument, which applies, obviously, in Wales, and that's not in the authorities bundle. Do we need to have regard to it?
My lady, I believe it's common between myself and my learned friend that the issues in this appeal do not turn on that statutory instrument and the difference between the Welsh law in that regard and the English law.
All right. Thank you.
My understanding, and I haven't looked at the Welsh instrument for a long time, is that there's a more sophisticated and wider range of responsibilities on Welsh local authorities under Part 3 of the Children Act to support children and their families. So I wonder whether there was a relevance that under a supervision order, in addition to the statutory responsibility under the supervision order, the local authority anyway would have responsibilities to these 3 children under the Welsh legislation, which would not be the case under the English legislation. But I may be entirely wrong.
No, my lord isn't at all, and that is the position that we accept. That's what presented by the Welsh law. The judge in this case, at first instance, considered that the crux of the matter was the sharing of parental responsibility and whether that was needed or not. And that's not something that we disagreed with on behalf of the appellant.
Okay, so talking in general terms, it is the case that if we were comparing England and Wales, the responsibility of the local authority generally, irrespective of the order, are greater, but that's irrelevant to the dispute in this case because the judge was operating in that climate and he knew that was...
Yes.
And so when he says there's no difference between the services that will be afforded to the family under a supervision order or a care order, that's in part what he would be likely to have in mind.
Indeed, and for the reason my lord has indicated, the judge at first instance wasn't addressed on the difference because in Wales we work within those differences.
That's the pool you're swimming in, yeah.
Indeed.
So the answer is I'm right in general terms, but it's not relevant.
Yes,
with respect.
my lord was absolutely right in general terms, but it's not something that I intend to focus on, subject to my lord's and my lady's views.
But it does mean that if clearly our judgments will be read in England as well as Wales, that in an English case there might be a difference between the services that would be afforded under a care order or under a supervision order.
Yes, that.
I think we just have to flag that up.
Might be useful to have it committed to us.
Yes.
And any submissions as to the differences between them, given what you've got
Yes.
your judgment to do.
Obviously not now, but it would be helpful to have, in very short terms on paper from the two of you, an indication of what differences there are. All I've got is, you've had my entirety of my my working knowledge of this, is that there are differences in the Welsh systems, and my view is better than the English system in terms of setting out greater responsibility on local authorities, irrespective of an order to support a family.
My Lord, indeed, I'll provide that.
Thank you.
I'm sure my learned friend can contribute.
Thank you. Right, back to where you thought you were.
Yes, I'm grateful. So it was 2 points on the authorities first. The law's well settled, so I'll make them briefly if I can. The first point emerges from a principle relied upon by both respondents in their skeleton arguments. Both respondents seek to rely on two cases. They're the first two authorities that appear after the legislation in the authorities bundle. First is Oxfordshire County Council and B from 1998, 3 FCR. And the second authority is RE-T, a child, from 2009, EWCA 121 Civ. In the respondent's skeleton arguments, it's suggested that the authorities make the same point, and that is, and I'm reading now from the respondent's skeleton arguments, I'll give you the reference afterwards. They say that a first instance court needs to satisfy itself that very cogent reasons exist before it imposes on a local authority an order that the local authority does not seek. That's at paragraph 32 in the skeleton on behalf of the local authority, and paragraph 15b on behalf of the skeleton for the children's guardian. With respect, we don't entirely agree that that's a correct statement of the principle. We say the principle is expressed actually as follows in the authorities, and it's expressed by Ms. Justice Hale, as she then was in Oxfordshire, first of all. And it's this.
So where do we find?
So in Oxfordshire, my lord, it's page 52 in the authorities bundle.
Oh.
Paragraph D.
Okay.
And it says this: cogent and strong reasons are required to force upon a local authority a more draconian order than for which it has asked. The same point is expressed, and it's actually citing Oxfordshire in RE-T, and that's on page 35 of the authorities bundle at paragraph 34. The difference between those two principles, of course, being that it is when a more draconian order is imposed, not just a different or lesser order, that the very cogent reasons are said to be required.
Yes.
It's a minor point, I accept, but the way it's actually stated is in keeping with the concept of proportionality. And it's important in this case, we say, because of course the first instance court was not being asked by the appellant to make a more draconian order, but the order of lesser intervention.
Yes.
My lord, that's the first point.
Thank you.
To move on to the second point on the authorities, and that flows from RE-T, the first case I've just referred to in the authorities bundle, and it may assist, particularly my lord, if my lord's had a late service of the authorities bundle, to turn to page 36.
Okay. Yes.
Excuse me, my lord. page 35. And it's Sir Mark Potter giving the judgment, who says, in my view, the necessity to
So
consider...
what paragraph are you on?
Paragraph 33.
That is 36. It's printed 35, but it's 36. Yeah, indeed.
In my view, the necessity to consider proportionality means that in any case where there is a fine balance to be struck as to which order is appropriate, the reasoning behind the order should be clearly spelt out in the judgment as a matter of detailed analysis rather than overall impression. That is in response to an earlier passage cited where it was suggested by a judge at first instance that a permissible approach was to look at the case as a whole, to look at the gravity of it, the risk of harm, and decide whether in light of that gravity the local authority ought to have imposed on it the extra duties associated with a care order. And that paragraph's 29, and specifically the second unnumbered hanging paragraph under 29. I wonder if my Lord would like me to pause there so my Lord can
Yes, so
consider.
that's the paragraph beginning, however, I do not believe.
It is.
Yeah.
It is that.
So we'll just read that quickly.
My Lord may be assisted as well by considering paragraph 31.
Yes, no, I've seen that. So the point is that His Honour Judge Coningsby, now sadly the late Judge Coningsby, was saying what he was saying in 1993, which is a good 7 years or so before the Human Rights Act.
It is, indeed.
Yeah. And so Sir Mark was saying we now have to read that with caution because it's important to look at proportionality,
Yes,
necessity.
yes. And then Sir Mark goes on to suggest that the detailed analysis is required.
Yeah.
If I can attempt now...
And of course, sorry to interrupt you, but it's right to say, isn't it, Re T is a case where the judge made an order that was contrary to what all parties wanted.
Yes, that's right.
Judge Ibbotson, who is happily still with us, made a care order, even though everybody in the case thought that the right order was a supervision order.
Indeed, that's exactly.
So we have to read some of these passages with that relatively important point in mind.
Yes, I don't detract from that.
Yeah.
What I would like to do, if I can, is try and apply the recent guidance from the Public Law Working Group to this analysis.
Yeah. Can I just really to set the context of this case? I think it's well known that there is a difference in culture between, in broad terms, if you draw a line from Hull through Stoke to the middle of the Bristol Channel, south of that line and east of that line, the courts are really unlikely to make a care order where the child's at home. North and west of that line, it's not uncommon, and it is done fairly regularly. And so Wales is in that latter category. Is that something that you and those who instruct Miss Lee, indeed Miss Lee, are aware of? That it's more, but this is not uncommon to have a care order.
Yes, I'm aware of the findings of the working group, and I'm aware of the statistics, but anecdotally in my practice, yes, during the time that I've practiced in the area, care orders with a care plan for children to reside at home have been made relatively frequently in the courts on the Wales and Chester circuit.
Yes, I think they might, and part of the reason why the Public Law Working Group looked at the issue was that there is this difference in culture.
Absolutely, and no doubt the higher courts wish for there to be some consistency.
Yes, no doubt. But what it is a moot question.
Well, referring to that guidance, and I know the court will be familiar with it, paragraph 37 says that it should be considered rare in the extreme that the risks of significant harm to the child are judged to be sufficient to merit the making of a care order, but nevertheless the risks can be managed with a care order with the child remaining in the care of the parents. This can only be justified if it is necessary and proportionate to the risks
Is it in
of harm to the
is it
child.
in the authorities bundle?
It is right at the back.
Okay, and what
My lord.
page are you reading from?
That was from page, electronic page 173.
Thank you very much.
And the court will know the guidance also states there should be exceptional reasons for a court to make a care order on the basis of such a plan.
Yeah.
To try and build in that earlier analysis, like Sir Mark Potter, we say that the reasons, the exceptional reasons, should be focused on how the particular features of a care order mitigate, to an extent which is required, the specific risks that exist in the particular case under consideration. And I contrast that submission with the passage I referred you from His Honour Judge Ibotson, who took the more generalised approach to assessing risk and then deciding which order is appropriate on that generalised assessment of risk. In my submission, in light of proportionality, it needs to be more specific than that. And if that approach is taken, we'll reach the position that the working group say we should reach, which is that it's exceptional or rare in the extreme, where it can be said on a care plan with a child remaining at home with a parent, that without a care order, the risks are too great and the child would have to be removed. But with a care order, the risks can be sufficiently managed. So
Can you think of any example, Mr. Llewellyn, in general, where it could be thought appropriate to consider a child being at home under a care order, excepting those cases where there's a reunification from foster care or a newborn baby fresh out of hospital on an interim care order at home? But have you, when you were preparing your case, thought of an example of one such case that may be appropriate? And I'm not asking about the authorities, I'm asking about a general situation.
If there was to be required intervention in the day-to-day parental responsibility of the caring parent, then in those circumstances it may be considered that a care order at home would be appropriate.
But what kind of day-to-day caring
For
to
example,
intervene, as it were, without the necessity of having to contemplate removing the child? That's the only difference, really, isn't it? The supervision order can help in the intervention of day-to-day parenting duties. But a care order is often fated in the courts as necessary because it will be contemplated that a situation may arise when the child has to be removed without further recourse to the courts. And I'm just trying to wonder, at such a case where the risk is thought to be proportionate for the child to be at home, but this fail-safe is there. That's what I'm really asking you about.
yes.
Have you thought about any such
Well, my lady,
case?
I've tried not to derogate from the guidance which says those cases would be, of course, exceptional. In terms of the removal point, which my lady makes, that, of course, has been substantially diminished by the authority of Reed EE and the judgment of Mr. Justice Baker, as he then was, who, on my reading of it, my lady, and I hope I'm correct, appears to suggest that there is very little difference between what a local authority needs to establish to remove a child, whether that is on an emergency basis or whether that is on a basis where it's not so urgent, but a further assessment through the looked after children process is commissioned, and the local authority can remove the child.
Yes, which leads you on to the question which I've posed. So, in what circumstances, and it's something that, if my Lord the President will permit me, I'll ask Miss Lee to think about, in what circumstances where a local authority is considering a care plan for a child to be at home, would it be necessary for them to have a care order? Because if the risks are high to the child, then the guidance would suggest that the child shouldn't be at home. But the local authority are positively putting towards the court that this child can be at home subject to the safeguard. And sometimes you can make good your case by thinking of an example or not being able to think of an example.
My lady, I'm not avoiding doing so. Can I suppose this, that in circumstances where there was an elder child who had a very strong attachment to their parents, and it was assessed by the professionals in the case that the removal of the child from the parents would cause significant immediate harm to that child and shouldn't be contemplated, but however, leaving the child in the placement, living with the parents, would still leave the child at a risk of significant harm, but a lesser one than if that child was immediately removed.
I see, thank you. So, on the balance?
Yes, indeed, balance of harm.
Thank you.
Yeah.
If then I can proceed to the main argument, which is in relation to ground one, as I say, the need for sharing parental responsibility in the case. The judge at first instance stated that that's what his decision was premised upon at paragraph 26 in his judgment. It comes down to the issue of the need and proportionality of sharing parental responsibility and ongoing intervention into the life of this family.
Then he mentions the Article 6 rights of the mother and the children. I didn't understand that reference.
No.
The Article 8 rights are obviously...
He goes on to mention the Article 8, but
Yeah.
yes, Article 6 as well.
But he then doesn't say anything further about Article 8.
No, it's
In particular, doesn't, given the issue that he had to decide, doesn't, by reference to Article 8, engage in an evaluation of proportionality.
No, I respectfully agree with my lord.
Yeah.
And what we say is that, linked with that point, neither the learned judge at first instance nor the respondents have identified to the required specificity what extra necessary protection is achieved by way of sharing parental responsibility with the appellant. If I can make...
Also, I just say this at this stage, partly so that Miss Lee can hear me say it. At no stage in the judgment does the judge mention the children at all. A reader of the judgment who doesn't know anything about the case knows that there are children, but whether there are 2, 3, 4, 5, 6, whether they're boys, girls, what age they are, there's no reference. The judge, obviously, this is a very seasoned judge, it's the designated family judge. But I make that observation because a point to consider is whether the boys are at risk from Mr. P in the same way, plainly, that the older girl who had vulnerabilities may well have been at risk.
Indeed.
And I don't think at any stage the judge looks individually at the children. And if one asks why was it necessary for these boys to be the subject of a care order, because Mr. P, in the course of his analysis with Dr. Gray, is really quite clear that his sexual interests don't go beyond girls.
My lord, yes.
I mean, he may not have been telling the truth, but there's no evaluation by the judge as to whether there is a distinction, and he's made a care order on all three children.
That must be right, and there was potential at least for a differentiation in terms of outcome. On that basis, I accept.
And do these children's fathers continue to have involvement in their lives?
The oldest child's father was a respondent and played a role in the proceedings.
Does he play a role in the lives of the children?
He has contact only with his own child.
But that, again, is something that should be put into the balance, isn't it? That there's an extra pair of eyes
Indeed.
looking
My lady,
at the
I agree
relevant
entirely.
children.
And I believe, in fact, that was a point made by his counsel at the final hearing.
Yes.
A point linked to that are the ages of the children, and at least the eldest child is effectively a pair of eyes in herself.
Well, she's got difficulties, hasn't she?
She has, but I'm
And
not sure.
sometimes victims can be overcome with their own problems if she did become a victim.
Indeed. I just make the point.
But there's
these
a
were-
parent who has an active involvement in her life and aware of the difficulties presented by this element that brings the matter to the court, would be an extra facility, an extra advocate for the child.
Indeed, I agree wholly. I do. The other advocate for the children was the appellant. And if I can very briefly consider two parts of the agreed expert evidence about the appellant. The first, and I don't ask my lordships or my ladyships to turn there at this point. The first is that the expert, and this is the quote, was impressed with the appellant's ability to place the needs of the children at the centre of her decision-making and to prioritise their needs.
What's the reference to that?
And that's at page 129 in the core bundle.
Yep.
And secondly, that the expert said this: I have not seen any information that would make me overly concerned about the appellant's capacity to work openly and honestly with professionals in the best interests of the children.
Can you just wait till I get that reference, because there's more than one number on these pages.
Yes.
So it's 129 in the bottom right-hand corner, not E129, that you wanted to refer us to.
It would be
It's not electronic 129.
Because E129 is Mr. Palmer.
sorry, I meant F129. If I didn't say that, I apologise.
Right. We've got an electronic number.
And my lady, I apologise.
No, no,
You're
no,
not
no.
assisted by.
The executive summary, is that what you were referring to?
I come there now.
I can't find F129.
If it's F129, it's E173 for my lord, but that's the executive summary.
Yes.
I've got
and it's
an F.
My lord, it's electronic page 232.
How about a paper reference for those of us that
Well,
work on paper?
It's section F, my
One.
lord, page 129. And
I've got a bundle that's numbered in an old-fashioned way from 1 all the way through to 300 and something.
129.
then,
129, the executive summary.
yes, that's right.
Yeah.
And it's the last sentence of the first paragraph.
Right, thank you.
I was impressed by
Yes.
Yeah.
P. I should have said at the beginning, and this case is being live streamed, that nothing is to be reported or published to identify any of the children or any of the family members as being related to the children. I think so far we've been very clear in not mentioning anyone's names.
Yes.
If we do, then nothing is to be published that would identify the children as being subject to these proceedings.
Indeed.
So that was your first reference, Mr. Llewellyn.
Yes, it was. Then the
And the
second
second?
is at page 187, F187, and I'll give an electronic. The electronic page 290,
290.
290, electronic page, my lady. Otherwise, otherwise section F,
These are very full reports, aren't they?
187, they are.
Is this heading, what is mother's capacity to work openly and honestly with the schools?
And it's the first sentence.
And I've highlighted that. I've not seen any information that would make me overly concerned.
Yes.
Yeah.
Sorry, that took me some time to give you the references.
All right.
So is the administration, which is difficult. We say that those two pieces of expert evidence were demonstrated in the ancillary evidence before the court, in that there'd never been any subterfuge or dishonesty on the part of the appellant in how she had conducted her relationship with the stepfather. And indeed, this is reflected in the judgment to an extent, where the judge says,
Did you mean her work with the stepfather?
pardon?
Yes, I think you did. I think what I took it as meaning was that the way she conducted herself with Mr. P was known. She
Yes.
never tried to hide the fact that he had come round to deliver shopping or whatever.
Indeed.
Is
Indeed.
that the point you made?
It is.
Yeah.
This was, unlike some cases where there's been evidence of evidence or findings of a covert
It's just
relationship.
that I thought you were saying that she was working with him. Your sentence read
Yes.
ambiguously. That's
Sorry.
the point, Mr. Ryan.
Not at all.
I do understand your point.
There we are. And I was,
And my, Ms. Lee will correct me, but I think certainly some of the occasions when she'd seen him, the social workers only know that she had seen him because she told them.
yes, indeed. That type of pattern is consistent in the case, in that it was the appellant who first told the social worker of her husband's conviction, and whilst she was on occasions, particularly earlier in the proceedings and pre-proceedings, defensive, she was in many ways an open book.
But it was really early days, wasn't it? There's also a history of her not accepting the local authorities' involvement. Well, if they were that concerned, why didn't they do something earlier? She apologised for the way she had previously acted with the social workers. And so that there was a feeling that if she was now in a relatively safe position, this was a pretty new position for her to be in, and that as the judge almost measures it day by day from the delivery of the expert's report on the 6th of October, whatever the date was, he was hearing the case on the 11th of November. This was all pretty new stuff, and that the earlier history was not, she was not involved in subterfuge, but she wasn't actually welcoming or accepting of the local authorities' basis for concern.
Not earlier on in the proceedings, my lord's entirely right. What I was trying to do was to delineate a difference, I hope it's not dancing on the head of a pin, between a parent being openly defensive with a local authority, but at least the local authority know what they've got then, they know what they're dealing with, contrasting that with a parent who is being less open and less transparent and is behaving...
Who's paying lip service to the need
yes,
for
my lady,
protection.
disguised compliance, and it's often called.
So this was open hostility on occasions because the mother did not appreciate, she said, subsequently, she did not appreciate the full contextual significance of what Mr. P was capable of in terms of manipulation and the like.
And of course, at that time, the appellant, at the time of the defensiveness, the appellant was in a relationship with the stepfather. They weren't living together because the safety plan had been in existence since the October before the proceedings were issued in the May. But they were in a de facto relationship. So it's fair to say she was likely influenced by him. Of course, that had changed by just a few weeks after the expert's interview and the expert's report. So what we say is the expert's opinion does marry up with the other evidence in the case and the judgment, where this is a mother who had put the children's needs first, hadn't slept, to use the judge's phrase, and had been open and honest with the local authority.
Has she started the Lucy Faithful Foundation work yet?
You're asking about presently,
Yes.
my lady. I believe it has started, only just.
Right.
There we are. Social workers nod at me. I had
Thank you.
base instructions. If I can turn to consider the judgment, then some points have been made by the court, and I fully accept them. The respondents place particular reliance on paragraphs 34 to 39. I don't intend to go through each of those paragraphs, but just to highlight some points, if I may, and this is with very much in mind my earlier submissions as to what is required in a case like this, and that is a detailed analysis of why particular features of a care order, and in this case, sharing parental responsibility, was necessary to mitigate the risks of the children staying at home. And if I may first consider paragraph 34, and what the judge says. So it's 6 lines down. It says also the sharing of parental responsibilities so that the local authority can effectively take the whip hand if need be, if there is a falling down of the safeguarding position at any point. Also, he says that the local authority, the care order would place on the local authority a positive duty to ensure the welfare of the child and protect the child from inadequate or risky parenting. That was again paragraph 34. With respect to the judge, these are non-specific features of a care order, not applied to the facts of this case. And at paragraph 35, the judge seeks to deal with the threshold of exceptionality, having in mind the guidance from the Public Law Working Group which had been considered during the hearing. But the judge there only refers to risks. He does not state how sharing parental responsibility would protect against those risks. and we say the court proceeds through each of those paragraphs individually. The judge doesn't do that at all.
It says it's a fine balance as well.
Yes.
So, query, if it's only finely balanced as being exceptional, is it exceptional? But that may be just for lawyers.
Indeed, it's a forceful point.
Unduly pedantic approach.
Before we leave paragraph 34, of course, you've said these are non-specific issues that the judge identifies, but also, I think he overstates it, doesn't he? Because it's not a care order that imposes a responsibility upon the local authority to ensure that children in need are, as it were, subject to appropriate parenting.
I agree entirely. It's the local authority has a statutory duty in
Yes.
any event, in Wales and England. A similar point, my lady, if I may, is, again in paragraph 34, it's identified a supervision order does not place the local authority under a statutory duty in terms of visitation to the property. Now, statutory duty in terms of visitation under a care order is, be corrected if I'm wrong, something like at frequencies of no more than 6 weekly.
Not sure it's written down, is it?
No, but that's as a matter of law how often a child needs to be visited if they are looked after. But in the context of this case, it may well be argued that at the beginning the local authority would want to visit more often than that. And they may want to tailor such a programme of visitation so that their visits became less frequent as they were content that the risks reduced. But that isn't a feature of sharing parental responsibility. And it would be open to the local authority to have a plan under a supervision order, as well as a care order, to visit more frequently than its statutory obligations of only 6 weekly. So we say that isn't a reason to choose between the orders either. If I can come to now make submissions on actually why sharing parental responsibility wasn't required in this case. The first submission is the judge hasn't dealt with this in the way in my submission he needed to. But if the learned judge had, this is the analysis that I say the court, first instance, should have arrived at. The first facet of a local authority sharing parental responsibility is doing so on a day-to-day basis. Now, this was, in effect, a single issue case. There were no other concerns in threshold or substantially in welfare which necessitated state intervention. At no point during the previous 6 months and pre-proceedings had the local authority been required to either seek or share parental responsibility. And this was, to rely on a point made earlier, despite the appellant being in a relationship at that time with the stepfather and likely being subject to his influence. Despite all of that, she'd not slipped and not put the children at a risk of harm.
I think you've got to be careful in Mr. Llewellyn. In this case, that may have some resonance with the rest of the fictional context. But one of the arguments that could be put forward is that, of course, somebody who is under the purview of court proceedings is going to behave, and therefore the judge has got to make an analysis of whether or not the demonstration by the parent within 6 months under a court order is likely to be illustrative of matters going further, or if the witnesses for the local authority or the guardian have reason to feel if there'd been an adverse psychological point, that mother can say all things to all men and women in order to meet the intellectual arguments.
Indeed.
But in this case, I can understand your submission, but I think if it's a general submission that you're making, that this court would have to be very careful about that, wouldn't it? Because otherwise, every case that came before the court where somebody said, well, for the last 6 months, I've done everything that was required of me, and the local authority have never had to step in, never had to say, we're going to remove the child, then everything is fine. You don't go that far, do you?
My lady, I don't. And
No.
it's not a determinative point in that way, but it's something which should be weighed in the balance.
Right.
Particularly as, in this case, to go back to my earlier submission, there wasn't a suggestion that this was a litigation position that
No.
the mother had adopted. But I take
That-
my
that's
lady's
a good
point
way
of
putting it,
principle
a litigation position.
entirely. Just finally on this point, of course it's a matter of law that even with a care order, when the local authority share parental responsibility, they should only activate that when it's necessary. They should only infringe on the parent's parental responsibility as a matter of statute when it needs to, and it hadn't needed to in the previous 6 months. We're taking my lady's point fully on board. We say it's a good indicator that the local authority wouldn't have needed to intervene on a day-to-day basis with parental responsibility in the proceeding period of time that would be relevant. The second facet of sharing parental responsibility, if I may move on to that, raised by my lady earlier, is the power of the local authority to remove the children. And the care plans in this case make clear that in the event of there being contact between the appellant and the stepfather, the local authority will convene a legal planning meeting to consider removing the children. Now, I touched upon this earlier, so I'll be brief, but as a result of REDE, which has been approved by this court, the requirements upon a local authority removing children from their home are the same, effectively, whether the local authority holds a care order or not. But it's been reflected by this court that Parliament intended that the removal of a child from its home should be done under sanction of judicial authority rather than a result of an administrative decision. And that is reflected in paragraph 35 of RET.
RET or RED?
That second point is reflected in RET at paragraph 35. Indeed, it's RET considering RED. Applying that to this case, these 3 children had always lived with their mother, had never been apart. Some of them had additional needs. In my submission, the prospect of this sibling group, with their ages and strong family connection, being removed from their mother's care and there being plans made for their permanency elsewhere, without the oversight of a children's guardian and without the oversight of the family court, is a troubling one. And to follow Lord Justice Baker's analysis through, in reality, any expressed intention from the local authority to remove the children would likely lead to the appellant issuing an application under the Human Rights Act, and we would be effectively back at square one, just with the appellant as the applicant and the local authority as the respondent, with the deficiency, probably, of the appellant not being legally funded.
Well, it's worse than that. There's the delay, isn't there? That an application under the Human Rights Act getting before the court is going to be considerably delayed in reality.
Indeed. I take the point entirely.
Or she would apply to revoke the care order. That would be.
Yes.
She wouldn't get legal aid for that either.
Not typically.
No.
And that's something raised by Sir Justice Baker, as he then was in Reed EE, that not typically funding isn't available, or often I should say funding isn't available as a non-specialist in legal aid funding. Often funding isn't available for those applications. They are means and merits tested, unlike
The automatic legal aid in care.
Indeed. Nowhere in the judgment at first instance is it reasoned why removal under a care order would be more beneficial than removal by way of an urgent application for an interim care order or an emergency protection order. And indeed, it's submitted for the analysis, on the basis of the analysis set out, that there would be no welfare benefit to a process of removal by an administrative decision. And if I may contemplate what the Public Law Working Group would say about this, I'd submit that it would reason that if a future removal was genuinely being contemplated as a reason to hold a care order, then the risks would usually be judged to be too great for the children to be in that placement with the parent. So for that reason, we say that the sharing of parental responsibility to allow for a future removal is unnecessary and wouldn't be justification for the care orders.
I think you go further. You say that the scenario you've described would be contrary to their best
Yes.
interests.
I think that's probably a better encapsulation of my point, my lord. So the judge in this case had said that the need for a care order came down to the proportionality and the need to share parental responsibility in the two ways that parental responsibility sharing would affect this family. In my submission, shown that it was not necessary and in fact may have been contrary to the children's welfare. And my lords, my lord and my lady, for those reasons we say that the judge was wrong to make care orders on that basis. There are other differences between the two orders. Indeed, my lord raised a difference, my lady raised a difference as well at the beginning. I'm content, together with my learned friend, to assist the court on paper if I can with those differences. But in this case, we say the differences came down to the sharing of parental responsibility,
Yes.
And the judge was wrong in what he said. Unless I can assist you any further at this stage, those would be my submissions.
But what about, I'm terribly sorry.
No, you were going to say the same thing.
Well, I was going to ask about the second ground
Yeah.
that you have, which is about
Indeed.
if the judge was right to be cautious, and certainly for myself, I understand the arguments that you've got and put forward as to the first point. What you go on to say is, if he was right to be cautious because of how raw the situation was, newly hatched as it were, then he should have delayed making an
Yes.
order. Now, I know you received less encouragement from the single judge to pursue this, but speaking for myself, I think it's something that is worthy of comment in this case.
Yes. My lady, the principal point that this is premised upon is that there was a very short period of time before service of the expert report and the final hearing. The report was shared with the appellant in a conference with myself on the 6th of October 2022. The final hearing was listed on the 11th of November that year, so some 35 days only between service of the report.
And your client must not, in a category of significant concern about her intellectual functioning is in a low level of ability in terms of her ability to read and take things in and understand matters.
Yes. Low, but not as low as the family court would often see.
No, but I would just
my Lord will well know.
these are big issues to take on board.
Absolutely.
The report is very full. The message from it is blindingly clear. We're not talking about subtle stuff here, but that part of the fact that you're measuring the time, we're dealing with someone who is probably less able than some others to take on board these matters at the first occasion that they hear about them.
Indeed, absolutely I agree with my Lord, and it may be weighed in that this was a mother who had quite strong Christian beliefs. So the termination of her marriage, although obviously necessary with the stark message, was a moving concept for her. So we say this was an incredibly short period of time for the appellant to demonstrate the appropriate response, because of course not only does the appellant need to make the decision, but also be able to evidence that decision before the court. And we say that she did everything that she could. Before the final hearing, she had issued divorce proceedings, sold her wedding and engagement ring, applied for an occupation and non-molestation order. She could have done much more in a month. Both her and her legal team acted with some vigour. But if the judge at first instance did consider it a fine balance, and if, and there's some words from the judge suggesting that some more time may have satisfied the court, that a less interventionist order was required. If that was the case, that the judge wasn't able to step down from making the care orders, then we say that a short, purposeful, but necessary adjournment of the proceedings would have been necessary. And of course, delay, I'm well aware of the family court's deterrence of delay, but delay to these children who were still under an interim supervision order was not to their great detriment, in my submission.
Well, it was more than a balance of convenience, wasn't it? There was, you would say, very positive reasons and positive, potentially, benefits to the children in just a short delay.
Yes, indeed.
And every case will depend on its own facts as to whether those accumulation of factors, the length of the delay, the effect upon the intervention taken to date, the ability to demonstrate anything else can be achieved.
Indeed, and the evidence was that the courses which were available, the courses I should say, which even in the interview with the expert, so prior to the report, in the interview with the expert, the appellant had sought and said she was interested and wanted to learn more and go on these courses. The courses were due to start early this year. So a short adjournment from the November hearing would have allowed time for at least the mother to approach and potentially commence those courses, demonstrating the willingness to comply.
And understanding, as I say, litigation positions are very easy to adopt, but some people attend courses and tick the boxes, but have no comprehension of what the courses reveal. But you'd say that that could be demonstrated with a little more time.
I do, and there's nothing in this case, my lady. I understand the point absolutely, but there was no evidence in this case that this was a mother who would be prone to either attending courses for purposes of lip service or that she'd be intellectually incapable of taking on the content, or that there's any other reason. And I go back to the points I raised from the expert, that this was a mother who put the needs of her children first. So you would expect on that basis.
Honest engagement.
Honest engagement, indeed.
Mr. Llewellyn, on this point, can I just ask you this? Obviously, in lots of cases, counsel will say, well, it would have been better if the judge had waited and if there'd been more time. And often that is a counsel of perfection. And also, it's quite often the case that a delay actually, it's quite difficult to identify whether there would have been any material difference. But at paragraph 37 of their judgment, on the face of it, the judge appears to indicate that some more time may well have made a difference, if I've read it correctly, because he said if this was a case where the mother had started working with the local authority earlier, less supportive of Mr. P, and maybe even undertaking some of the work, then I would have been more amenable to the making of a supervision order. So on the face of it, unlike quite often, that's your causation point, isn't it? That you can point here to the fact that potentially, at any rate, the delay would have made a difference.
My Lord, I entirely agree, and indeed in my skeleton argument, that's where I was turning to. Paragraph 37 is what I've identified supports this point.
Well, paragraph 37 is clearly quite an important point in the judge's reasoning, but you rely on it for that reason.
Yes, absolutely. I do. It was in the judge's mind clearly that some time may give him the evidence, or maybe likely would give him the evidence required for him to take a step down from the order he felt that he had to make. Sorry if I gave the impression I was trying to abandon that ground. I wasn't. Grateful for my lady inviting me to make it good. It's very much in the alternative to the first.
Yes.
Do you want me to make submissions as to... Sorry, my lord.
No, carry on.
I was going to say that do you need submissions as to what the remedy would be if you granted the appeal on that ground?
No, I don't think we do. No. Can I take you back? Can you just help me? I'm looking at paragraph 20 of the judgment, which is on electronic page 98. So page 4 of the judgment.
Yes.
Section. Paragraph 20 is the last sentence. Albeit that they are heartened to see the steps she's taken in the last few days, it's submitted on their behalf, that's the local authority's behalf, that it's too soon to reduce, in this case, the protection afforded this family by any order less than a care order. Well, there hadn't been a care order. What should we? This is the local authority's submission. It's not the judge's decision. But was the judge in error there, considering that there was a reduction, or might he have in mind my lady's point that no matter what order was made on an interim basis, the fact that this mother was under the spotlight in the care proceedings provided an element of enhanced protection to the family.
Yes, my lord.
It's not a point you take.
But before my lord set it out, that would be the only way in which it would make sense, I believe.
Yes.
That there was some enhanced protection by the spotlight, as it's often.
Yeah, but it's not a point you take in criticism of the judge.
No, I don't think it is. And I'm trying to remember the local authority submissions. They're on paper, but indeed that the proceedings themselves may provide some further supervision is probably fair.
Thank you, Miss. Any questions? No. No. Thank you, Miss.
Very good.
Yes, Miss Lee.
My lady. In terms of the structure for my submissions, I tend just to address initially a point that was raised by my lady to answer that. I then, if I may, wanted to draw the court's attention in my submissions to points that I say are very relevant to the build-up to the final hearing and how the case management in this case developed, the evidence that was before the court. I also wish to take the court to some additional points in Professor Gray's report, which in my submission, when I turn to them, I'll be submitting, perhaps balance the other positives as to the mother's engagement as identified by the expert. And I'll then turn to perhaps one of the central points about proportionality. And then I'll deal with ground 2, if I may.
Thank you.
So first of all, in response to Milady's question, the Lucy Faithfull Foundation work, I've had confirmation from the social work team this morning that pleasingly the mothers had the first session, the sort of introductory session, and then the therapeutic work will commence hereafter, and the mother is committed to that, and the social worker's understanding is that that is proceeding.
Right, so she's had the first session.
So she's had the sort of meeting, a sort of first meeting, but it's not a therapy session, it's a introductory session, I imagine, to then set out how the sessions will be structured and so on.
Right. But once she's had that, it's presumably the following sessions will take place.
Exactly.
Yes. And it was thought to take 3 months?
Yes.
That's what the judge-
I don't have any additional feedback on time frame. If I do, I will ascertain that as soon as I can.
Thank you.
I'll turn then to the background of the case, and unless my learned friend corrects me, my understanding of how the appeal is put is that it's not a criticism in terms of the quality of the local authority work that was advanced at this hearing. It's about the decision of the judge and the trial judge. However, if I may, and I do say that it supports the submission as to why the judge wasn't wrong, I do just remind the court about the background as of course set out in the final threshold document, which my lady will find in the bundle. It's at F28 is the paper reference. In terms of the we'll find the other references as well, the electronic references. Indeed, in order to perhaps assist with the flow of submissions, if I make any references to the core bundle, I can then send through any additional electronic bundle references if I don't find them immediately, and I will do that immediately after the hearing. But also, I do submit that the court had the benefit of very detailed local authority final evidence in this case. There's a very detailed social work statement, and in particular the analysis section of that statement. The table format, where considering the different type of orders, the court will find that at F339, where final supervision orders are considered and discounted is the phrase that is used. I'll just find that page. It links into the previous page as well, where the different types of orders are considered. So beginning at 338, which is electronic bundle reference 441, and through to following page, the type of order, I just wish to make the point, was fully addressed.
This is in the CAFCAS report.
No, this is the social work statement.
There wasn't a CAFCAS report, was there?
No, I will deal with that very briefly, but there wasn't. The
It's
format,
just got at the top right hand.
It's got CAFCAS on the top.
I know.
Yeah.
But I know it is the social worker's final
It's
statement.
their SWET.
It's called a, yes, a
And
SWAT.
SWET is social work evaluation template, is it?
Yes, the
It's a bit of a guess, but
yeah, I know it says CAFAS, but that is the first page is electronic bundle reference 417 F314, which has the name of the social worker in that's the initial page. To assist, the format is very similar to a CAFCAS report.
right.
But there we
So
are.
going back to the point you're making,
Yes.
on 338, we've
Yes.
got the 3 children, first option, moving to live with another family,
Yes.
discounted. 3 of them remaining with the mother under no order, discounted. So that's, you rely on that.
Yes,
And then supervision order, discounted. And then
yes, because the supervision order discounted paragraph makes reference to the arguments that have already been put. So I just wish to draw the court to the previous page. In addition, I do make this submission. The final care plans for all three children in my submission were extremely detailed. And in particular, if I turn to the female child of the family and the two references within the final care plan, it's the page reference is F206, and I'll just find the electronic reference. The care plan begins at electronic reference 309, but in particular it's page F218, electronic bundle reference 321, which sets out the services provided to the child. It goes over the page also, sorry, I'll just also briefly. The next page also addresses, importantly in my submission, the services provided to parents. And on page F219 to 220, so that's 322 to 323, there is an extensive list in my submission of work and support that is going to be provided.
In any event?
Well, my lady says it in any event.
It was a question.
Yes,
sorry,
it's a question.
I meant to put the question mark at the end, so in any event?
Well, my lady, because of how the care plan was structured in supporting the care order, it doesn't give a separate line saying in any event. It doesn't have
that's
that.
the question,
Yeah.
isn't it? Because if these services would be provided to a child at home under whatever order, and it is in the interest of the child to receive these services, what the public law working group were very concerned about is that people shouldn't be subject to orders merely to effect or access orders, or forgive me, services that should be available to them in any event. So these services, which start at 4.7 to be
Yes.
provided for A,
Yes,
and then other services to be provided to mother in particular,
yes.
what is it about any of them that could only be offered subject to a care order? Is it a matter of finances?
No, and it wasn't a matter
Priorities?
of finances. It was the point underpinning this care order is that it was about the necessity to share parental responsibility
I
and the
understand that.
proportionality, rather than my understanding being about the provision of services.
So if you look at
why have you taken us to the list of services?
Because I was making the point that when the judge was making the decision, the level of knowledge that the court had at that final hearing,
Right.
and understanding as to, in respect of all three children, I won't go to all three care plans, but my submission is that there's a high level of support for all three children, was before the court.
But didn't the judge say, and why wouldn't these services be available under a supervision order? I know you weren't there, Leslie, but...
It was paragraph 24 and 25.
I wasn't there, Manny, but I think that the arguments, as I read them, for that were more about the risk that existed on that hearing, that was apparent at that hearing, and I'm just going to expand my submissions to come on to that, as to why that, in the balance, tipped the court to make
So the point you're making is, look at this list. This shows that this wasn't all right on the ground. It would only be all right in time if the mother engaged with each of these interventions. This was a high
Yes,
level
yes,
case
exactly.
in terms of what was still needed.
Yes, and I will go on and develop my point as to that, as to what was apparent and what the evidence was at that final hearing about balancing all of those risks at that time. I then accept I'll need to address that as respect to ground 2 and the adjournment point. But what I do submit is that in terms of the preparation for the final hearing, and I raise this because the need for that careful preparation is a feature in as some points in the case law. But here we have judicial continuity, importantly. It was identified at the IRH, which was on the 12th of October, that legal arguments around final supervision order versus final care order, I can put it like that, were likely to be central. And therefore, the court had all of that evidence and the agreed legal framework, which my lady will find in the bundle at F295, plus the detailed local authority case summary, the local authority closing submissions. So I submit that judicial continuity that identified that this was going to be the key issue, and that therefore I submit that this was a good example of preparation for that hearing. In terms of what wasn't at that hearing is the Guardian's final analysis, and my Lord has mentioned that point. It's not an issue that's being raised by the appellant, as I understand it, and it doesn't feature as an issue that was needed to be addressed separately. But there was ill health by the Guardian, as my Lord, my Lady have seen. But that was addressed by a manager being able to step in and prepare at least that position statement, which was before the court. No party sought the matter to be adjourned for that analysis to be obtained. So I do submit that the stage was set, if I can put it like that, at that final hearing for all of the relevant and necessary evidence for the court to make that informed decision about this legal argument, care order versus supervision order.
Judge says, sorry to cut right across you, didn't I? The judge says, and just looking at the Guardian's position statement, page 308, in the printed bundle, page 411, summarises the evidence. Then it's paragraph 14. On the basis of the above information, in the light of the fact that past Mrs. B indicates her relationship and trust of local authorities are living still very early days, Mrs. B still appears to have some grievance and criticism of the local authorities' conduct. The Guardian respectfully recommends that care orders be granted. And they are fully aware of the recommendations of the Public Law Working Group, but considers this case falls into the category of care orders more appropriate. So it doesn't quite go as the judge says, that the Guardian supported the categorisation of this case as exceptional. Not in the position statement in words, but that's effectively what she was saying. Yeah.
And I don't have the benefit of knowing the oral submissions that were made,
No.
but I accept.
But we have to assume that's what.
Yes.
And indeed, the Guardian had been on the front foot at the interim stage by saying there should be an ICO rather than an interim supervision order.
Yes. So, and also in terms of concluding the submissions I wish to make about what was before the court at that final hearing, I wish to turn to some other reference in Professor Gray's report. Of course, any report needs to be taken, of course, in its totality. But in respect of the report that was carried out in the assessment of the husband, or stepfather, refer to him in that way, F45 to 47 is the summary section. It's quoted at length, and I think perhaps all three skeleton arguments, but I refer again to that summary. Also, I turn to F103.
Well, hang on. So F45.
Yes, I'll give you. I'll just find the. So it's electronic page beginning at 148.
Thank you. Thank you.
And then at the risk factors in respect of this adult are obviously highlighted through the report, but at F103, I'll just find the reference for that.
Before you move on, Miss Lee,
Yes.
this executive summary
Yes.
between 45 and 47 is solely concerned with the risks presented by the stepfather.
Yes.
and it's not surprising to see the descriptors used as to how people groom and manipulate and the like. But this executive summary, while saying that obviously it's imperative that the children be safeguarded from physical or emotional harm, doesn't include any input as to the ability of the mother to do so.
No, and the submission I make, sorry,
No, so I was just going on to say, so is there anything in this that you ask us to read across which isn't explicit?
I accept the points are all explicit about the risk of this adult. They are wide-ranging and very serious, quite plainly, of course. But what we also have as part of the reference is a lack of motivation for him to undertake therapy. That's at F124. And all of these points and the seriousness of it, in my submission then, put even more responsibility upon the mother with the support the local authorities say that was needed through a care order to help her manage the gravity and the seriousness of the risk of this individual.
See what you're saying.
So that's the point I wish to make about it. Of course, I absolutely make it clear that the points Professor Gray acknowledges the mother has in terms of her wish to engage and so on is there, but it has to be looked at in that context. So there are other references that I perhaps then don't need to turn to, but I'll just risk the type of issues is the risk of relapse into alcohol, depressive instability of mood, the likelihood of non-compliance is clear throughout the report, particularly identified at F108, and this risk being dynamic as it's described. And it's that dynamic risk in particular which created the delicate position, perhaps, that the mother was then placed in, but we submit was supported and could only be supported through that care order. So it is that combination. That's the point I wanted to make about it. And in respect of the report for the mother at F132, there's this point about it's likely to trigger a period of emotional and behavioural instability by the husband, and that is something the mother was going to have to manage, along, as we say, supported by the local authority.
I can't imagine Miss Lee, given the care, as you demonstrated, that went into the preparation of the care plans and the consideration and all the rest of it, that the social workers who'd been involved with this family would say, if it's no care order, we're going to step back and the mother can take care of all of this on her own. Because they would be in a more experienced position to say this is going to be a danger period. We've got to go in more often when the father's likely to be in his low moods or in his cups or whatever. Yes. So it isn't an either-or situation, is it?
I accept it's not an either-or situation. There has been continuity of the social worker prepared and then still remains the social worker. But I do say that it is that the key point is that it was relatively recent. I accept what is said about the mother's engagement, but when one looks at the chronology in full, I submit that there are breaches, of course, of the safety plan over the summer of 2020.
The judge said there were no breaches.
No, sorry, forgive me. I'm so sorry. The concerns about possible breaches, I really apologise for that. But when looking at the chronology over the summer, there isn't that acknowledgement or insight, and I say that that's how it was. It's only very recent. It was on the receipt of the report, and what was the position was the Lucy Faithful work hadn't, of course, started, and the risk could not in any way reduced if it was at that high point. It's at this high point, but the court at that stage did have all the evidence before it in order to go on and make final orders. That perhaps goes to the adjournment point, which I will address. So I wish to say this in respect of the public law working group points. my learner friend has quite properly highlighted the high bar that it needs to be rare for care orders at home. That is the clear guidance. That is reflected in the case law thus far. But rare doesn't mean that it never happens, is my submission. It does mean that very occasionally care orders at home can and should be made, and only after careful consideration. And the local authority, I submit for the local authority in this case, that the building blocks have been put in place by the court to ensure that at that final hearing there was the sufficient evidence, there was the totality of the evidence, including the mother who was then able to file her statement, confirm that she would engage, set out the list of services, etc., available, and the legal arguments. And the acknowledgement that it is rare, I don't step away from that at all. But it is, my lady made a point to my learner friend earlier as to give an example of a case when is it rare, appropriate, or necessary and proportionate to have that care order at home. In my respectful submission, this is precisely that rare type of case.
Why? What was going to happen in this case if a care order was made that wouldn't happen under a supervision order?
Because it was identified that the elements of risk and the elements of...
No, what was going to happen under a care order that wouldn't happen under a supervision order?
Well, you've got that statutory duty and that need to share parental
So
responsibilities.
what was going to happen as a result of the sharing of the parental responsibility, what was going to happen to these children that was different under a care order to that would be the case under a supervision order?
It would mean that the local authority in this situation was as set out, would convene that legal planning meeting.
So they'd remove the children?
Well, I'm just saying that
That's the difference, that they would administratively decide to remove the children, whereas under a supervision order, they'd have to come back to court to remove the children.
That ability, if needed, would be there in a case where we say the risks are that high.
Do you accept that removing these 3 children from the care of their mother, in whose care they have always been together, removing them to foster care, maybe all 3 together, maybe not, would be a very major step?
Absolutely, yes.
Where does the judge analyse the impact on the 3 children of an administrative removal by the local authority under a care order, as opposed to a situation which, if awfully the risk came to be realised, the local authority decided they needed to be removed but had to come back to court to apply for removal?
Well, in terms of the analysis, I can only say see what everybody can see that's in the judgment, but I just make
it's not
this
there, is it?
submission.
And and I think you're right, if the difference is between a supervision and a care order, that the local authority would have the power to remove the children without going back to the court, then shouldn't the judge have gone to that and said, I think in this case the local authority need to have the ability to move in and just remove the children without coming back to court?
Well, what the submission
and weigh up the impact of it on them.
Well, the submission I make is that this judge had the benefit of that very detailed evidence at the final hearing. So obviously I don't know what was in the judge's mind, but I do say that it was with that knowledge and with that evidence that the court took the view that and obviously I refer more to paragraphs 34 to 39 of the judgment, where I say he did consider...
With respect to the judge, it's all
Yes.
woolly stuff. It's all about sharing parental responsibility. We don't see what the impact on the children is of the choice between the 2 orders.
Well, I submit then that it must therefore be implicit, I think is how I can best put it, that it was in the judge's contemplation, given the level of evidence that the court had, the very detailed documents, and the submissions that it had, that it formed the view.
But Miss Lee, we've heard from Mr. Llewellyn.
Yes.
In fact, the evidence that was before the judge indicated that if Mr. P came back on the scene, in fact what would happen is that a meeting would be convened.
Yes.
Which suggests that there is some time delay that there is some contemplation of the necessity,
Yes.
or even in the administrative execution of removal, for there to be considered, for example, the views of others, including mother, including children's guardian. So there was that indication to the judge that this isn't a case where there's an alert that it may be necessary, given the high risk of X, Y, or Z, that local authority agents, because it may involve police officers or the like, would have to swoop to remove a child from imminent danger. Now, in those circumstances, my Lord's point is, so the administrative decision is perhaps then considered, but the judge hasn't indicated in his judgment that he recognises that there's going to be another step. There's going to be no grave, risk that's identified that's going to cause the local authority to swoop.
I accept it is not in that. It is not in the judgment in the way as set out. But a separate point that I make as to why the judge was right on that occasion is I've already made it clear that it wasn't a case of resource-driven. It was not a resource-driven issue, that it had to be a care order to give the support. However, it is right that with that additional statutory duty under a care order, the obligations on a local authority, not just that the visits, which in themselves are important, of course, but it does give an extra level of responsibility for any local authority in a situation where there were heightened risks, serious risks, and in a situation where the work was yet to start for the mother. And that as a, because therefore, I anticipate question may be, but why should the child take the responsibility for that, with that infringement on them? But it's about a balance, and I do say it comes back to this proportionality. When you're dealing with one of the rare cases, which I submit this is, where that care order was justified on balance, then the need to overall ensure that there's that statutory oversight, not just oversight, but involvement, active involvement of a care order, that sharing of parental responsibility. It does fall into one of those cases, those rare cases, rather than assisting and befriending under a supervision order.
Ms. Lee, I mean, it's not just a case, is it, of the judge saying these risks exist. What the judge has got to do is to evaluate the likelihood of the risk.
Yes.
And it can be that if the risk is very great, the significance of the harm that would be caused if the risk came to be may weigh in the balance. In this case, part of Mr. Llewellyn's case with respect is the judge did not evaluate the risk of the stepfather with a view to the mitigation of which there was evidence provided by the mother. So it's not just a matter of a judge saying there are awful risks that I can contemplate, and he got evidence to say the risk is posed by Mr. P. There's no two questions or two ways about that, and Mr. Llewellyn hasn't attempted to say otherwise. But Mr. Llewellyn is saying that that's not the end of the matter. You identify the risk, you identify the likelihood of it occurring, and in this case, if Mr. P remained in the family, it's a great risk. But the judge then must go on to deal with the facts as they are, which is Mr. P is not in the family, and the mother is assessed by a psychologist as providing and being able to be reinforced in her capacity with protective measures, instincts, So that lessens the risk. I mean, that's part of an evaluation that perhaps we don't see in here.
But what I would say in response is it's not just the mitigation, which I accept my learner friend has set out. It's into that scenario of this potential trigger of a acute period of time for the family.
So why doesn't the judge then add in, and of course, because the local authority are particularly aware of these risks, they are going to be on the lookout. I mean, these are all things for him to put into the balance in order to achieve a proportionate outcome that respects Article 8 rights and, above all, protects the children's welfare, physical, but also emotional. Isn't that right?
In my submission, I say that the judge had that had all the necessary information and took it all into account, and was careful to do so. I say that's reflected in the careful preparation in the run-up to that final hearing. In terms of the proportionality point, I've perhaps veered into addressing some of those arguments already and those points already. But my learned friend sets them out in paragraph 68 of his skeleton argument. At the heading, I think it's disproportionality, in fact. The E40, I'll just find the electronic reference as well.
I thought it was from your computer.
No, it's not. I don't know.
I think it's outside.
Is it all right?
I think it's outside.
There's something reversing.
It sounds like that, but I think
But there's a beeping noise we can hear, which is my hearing aids are picking up very loud.
yes, I think it's from
It is a
outside.
feature of this court.
Oh, is it? It happens.
Distracting.
It's one of the joys of Court 71.
I was once, I think, in this court, or the one downstairs, in front of Lord Justice Alan Ward, and I was not doing very well in the submissions I was making, and he was sitting with two members of the court who'd been former law commissioners. They were fairly dry sticks, and it was really not very easy. And then a pneumatic drill opened up outside, and I said, "Oh dear, my lord, this is going to make matters harder at my submissions." And Lord Justice Alan Ward said, "Well, maybe, Mr. McFarlane, things will go better for you. Now we can't hear you." But that doesn't apply, Ms. Dean.
Well, whether the beeping absence or not, it's electronic bundle page 59.
Thank you.
It's the paragraph headed disproportionality. So perhaps in some ways that encapsulates the points on this issue that my learner friend sets out. So in response to those...
Sorry, this document is Professor Gray's report?
No,
electronic
it's
page...
an argument.
It's the skeleton.
Yeah, sorry, I'm sorry.
Yeah, no, it's my fault for giving the anecdote. I've forgotten what we were doing.
No, it's fine.
So are you taking us to paragraph 48,
No,
which
I'm
refers back to paragraph 59? Because
no.
that's on page 59. So if you want to take us to paragraph 59 of the appellant's argument...
69, paragraph 69.
69?
Yes, which is electronic bundle 58 and is page 40, B40.
Yeah, I have it now, thank you.
Sorry, thank you.
It's paragraph 68.
Yes.
68, yeah. So that's where Mr. Llewellyn sets up the disproportionality.
Yeah, so I just thought, just in terms of this, I perhaps covered some of the points already, but in terms of the first point, one there, and the point is made that the mother placed the children at risk of harm whilst in the pre-bleeding under a safety plan. I submit that the context needs to be considered wider because it was the mother's progress in acknowledging what the actual risks were. And I perhaps don't mean this particularly as a sort of criticism of the mother in a way, but it was It took through 2022. I'll put it in broadly that, and the references are there in the social work evidence. But for that acknowledgement, and it is only in that run-up to the first of all the IRH, but then that final hearing, that a willingness perhaps to very much fully engage with the local authority and acknowledge what was happening. So I also wish to make the point about, that's the point my lady made earlier, that it's about the reality of there being court proceedings in place. And I do make the submission that if there are court proceedings are ongoing, with the benefit of legal advice and so on, it can be that acts as an incentive for a parent to say that they are participating and they're committed. Not stepping away from what Professor Gray has said about the mother, but I just say that that scenario was about to change. So in terms of the second point too, the point is made, and indeed we perhaps stressed this earlier about the regulations, because what I say is that if, as at the outset, my lord, my lady addressed the provisions in Wales, if they're slightly different, that isn't a point that's being advanced particularly by the appellant. No. In this case, there's been the discussion in the courtroom about those. But even if there is additional support, it doesn't provide that sharing of parental responsibility, and that this is also a case, as I say, where there were services set out, but that need to support on a statutory basis and share that parental responsibility. I'll return to that submission. The third point, the judgment identified that a care order places a statutory duty, and then it sets out about a care plan with frequency of visits, and that perhaps something else could be done. It's a similar point really, but there was no sort of. I submit that the care plans that were before the court were comprehensive. It didn't require a frequency of visits because of the detail of involvement there was going to be, and we say underpinned further by a care order, but that wasn't going to be ameliorated by perhaps a list or a list of schedule of visits.
But isn't that the point Mr. Llewellyn makes, which is the judge puts emphasis on the fact that a care order will necessitate visitation of the home.
Yes.
Which a supervision order wouldn't. And I think Mr. Llewellyn's point, and he puts it more eloquently than I, is that this isn't a deciding factor because there is no statutory minimum nor maximum. It depends upon the facts of the case. So if under a supervision order at particular times of high risk, the social workers decided we must make visits today, it doesn't matter under what auspices that takes place, whether it's care order or supervision order. So I think you're arguing a point against yourself, aren't you, there?
Well, I think how it's put on behalf of the appellant, I make this, I suppose, the central point is that even listing the frequency of visits wasn't going to address the acute issues in the case.
Oh.
In terms of Roman 4, the bottom of that page, the point about the timing, effectively, and where the judge says, I'm concerned that the mother has chosen when and where the children should be seen. It is pointed out that was prior to proceedings. The submission I make, I'm returning to one I've already made, but it isn't as direct as that. The mother's journey to acknowledging, to willingly work with the local authority was not limited at pre-proceedings. It carried through, And whilst it is apparent now, absolutely accepted, it isn't right to limit it in the way that is set out there. So that's my response to that point. In terms of paragraph 5, at the beginning of the next page, it says the judge accepted the number of the risks posed by the adult only manifested if the mother allows him back into his life. And then it goes on to say about the mother had not being dishonest about the relationship and being forthcoming. I submit that the risks weren't limited in that way, and that it is reflected elsewhere. Well, it's reflected completely through Professor Gray, but also apparent from the papers that it wasn't limited to that because of the manipulative person that this adult was. There were going to be significant pressures potentially borne upon the mother at this crucial time when she needs to begin and engage with the work. In terms of the points, the final 2 points, that whether the police or Marek, etc., could manage it, could manage effectively any residual risk, and that it's the submission there by the appellant is that it's coming from the wrong way, effectively. I submit that isn't the case, again, because I return to the point about the levels of risk that were apparent at that time, and the work that had to be taken before. It's not just a residual risk, it's a high risk. And in terms of the final point, 7 there, all services could be provided under FCO, that's accepted by the judge. The mother had agreed to each provision. I've already addressed the point about the services, but it wasn't limited to that. This local authority, as I've said and repeat, thought it was important to have that additional statutory sharing of parental responsibility.
In terms of risk, do the local authorities say there's a difference in the risk of harm as between the boys and the girl?
I think as I read the local authority case as it was set out, it was too difficult to differentiate in the sense of where the case had come to in terms of the work to be undertaken at that time. So what I mean by that is the high risk was, of course, this adult engineering themselves into the family in any way, and in the end, before we get to the level of risk of sexual risk, if it assists, I can take instructions on that point, because I hear the point that my lord is making.
Yeah.
I can quickly turn. Would that assist? Or
Well, we, I don't think we need to.
apologies for not being able to assist on
Don't worry.
that point exactly, but it's so I turn then perhaps to the ground 2 and the adjournment aspect. The central submission I make is adjourn for how long, for what time period. In my submission, any delay has to be, of course, planned and purposeful. It needs to have structure. It needs to anticipate, in my submission, a review period, and none of that would have been possible in my submission at the time those final orders were made. The case of Re-P.
Well, there's
Yeah.
it's a question of what would happen during the time. Certainly,
Yeah.
if the adjournment would be until the Lucy Faithful work has been undertaken and at least some of the other work in the list of interventions, that's an open-ended time frame as at
Yes.
11th of November.
Yes.
And we know now that here we are March, it probably won't be finished until June. So we're looking, for a significant period. separately, the judge might have said, well, let's adjourn it for 3 months and see whether she sticks to this new way of living that she's now saying that she's going to embark upon. So that, as the judge says, a number of times, it's very early days that the penny's dropped, but it's only dropped in mid-October, and here we are in mid-November.
Yes.
And the risk is there, he says, and it's more significant at the beginning of the period than it is at the end. So if you're just looking at how the mother is behaving, irrespective of interventions and therapy, then you might say 3 months or something of that order. So I think there are two separate, when you're looking at timescales, there's at least two separate drivers, as it were, that might determine how long it would be.
But it was the, it was the acknowledgement of Professor Gray of the potential risk for the children, in their minority of this adult. It's a wide-ranging risk, and in terms of time scales,
he's unreconstructed. He's at risk to children everywhere.
Yes.
If he, I think you used a good word, and engineers himself into a family setting. So part of the equation is that, but part of it is how the mother is able to defend her children and protect them. If she builds the equivalent of a ring fence around her family and prevents him coming in, then he's never going to have the opportunity to engineer. So it's not just a case that he's a risk for the whole of their childhood.
No, I accept
it's how that risk is to be met.
It is, but I submit that it's difficult to see, given how high that risk is, with an adjournment of say 3 or 4 months. What may be known is the mother's engagement. It would be recorded her engagement with the work and services, but the factors beyond her control, if you like, and his behaviour, and therefore potential risk to the family, submit that would still be extremely high, and it would be difficult, save for a whole further assessment period potentially, as to whether whether the mother's progress had then reduced the overall risk. You would then be working in a vacuum because you wouldn't have a further assessment of the adult, and that would be an issue that would be perpetuating effectively if there are adjournments to then consider it. And that's why we say it falls into this rare category. So I submit that the case of Re-P, for example, there was a very clear reason for that adjournment in that case. It was a mother who had been abstinent from alcohol for a very clearly recorded period of time, and therefore there was planned and purposeful delay to undertake a further assessment and come back. This isn't that case. This is this rare case where the risks, notwithstanding, and fully acknowledge the mother's engagement with Lucy Faithful, etc., and the social worker now, absolutely. But there are these other factors that keep the risk at that very high level.
Although I think it's fair to say, isn't it, that and very careful, as far as I can tell, very careful social work identified this timing issue as a problem, because page 333, which is back to the sweat, it's page 20 of it.
Yes.
There's a long paragraph that starts, however, the assessment.
Yes.
And then at the bottom of that paragraph, 5 lines up, however, this decision is a very recent one, under 2 weeks. Therefore, the assessment was not able to conclude with any certainty whether Mrs. Palmer is able to protect the children. A further period is required to establish whether Mrs. Palmer is able to follow through with ending her marriage to Mr. Palmer, and also whether she is able to follow the strong recommendations within the risk assessment. So they were saying a further period was required.
And my understanding, and my learner friend will be able to assist me as to the IRH. What happened? This is, of course, prepared in advance of.
Yes, no, I get that.
The parties did apply, as I understand it, for an adjournment.
They did, didn't they?
All of the parties.
I thought it was not
I
supposed.
understood that too, which is why I was rather surprised to see that there was such vehement opposition to ground 2 from the local authority, because at one stage they themselves contemplated that further delay would be beneficial in this case.
And what changed? In answer to that question, then we have the mothers. She then has that benefit of that important legal advice between that period. She files a statement. There's a level of commitment, as I understand it, then to the work within the care plans, which, from the local authority's point of view, reduced any need for an adjournment, which is why one, as I understand it, wasn't sought. But I can again turn.
That seems to be counterintuitive, though, with respects, because if what the local authority is saying is we needed the brickbat of the ongoing proceedings to get Mother to the Lucy Faithfull Foundation, that actually would suggest rather more a litigation position on the part of the mother rather than a willing compliance with a suggestion that she attend for the benefit of the children. So if the local authority were afraid that it's only the fear of proceedings that drives her to take up this work, then there'd be more reason to say to the judge at the final analysis, we are very, very concerned that absent the spotlight of the care proceedings or absent an order, that Mother will not comply. But as I understood it at the IRH,
Yes.
what people were saying is we need to develop this further to see how it actually does fall out. And that's, it might be thought to be, in this case, a very appropriate thing to say. But I didn't understand from the papers that the local authority were playing, as it were, a litigation position point in suggesting the delay. I thought that they wanted to know whether Mother was committed to going through with the end of the marriage, the cessation of all contact and the rest.
Yes.
Which was still in existence at the time of the final hearing, wasn't it? The wish of the local authority to see just how committed Mother was.
Well, no. I mean, my understanding is then the local authority reflect on the position of the mother and take the view that the final orders can be.
But the mother had changed for the better in the 6 weeks from the local authority perspective, because it's far better to have a mother saying, I now understand, than, you know, I resent everything that you've done. But she'd made a sea change, hadn't she?
But still very new, in a highly complex and very vulnerable position for everybody involved. I mean, it's not just the newness of it; it's the context of that. Yeah, which I've already made those points. So.
In terms of the timescale, paragraph 33 of the judgment.
Yes.
So I'm on electronic, page 100, page 6 of the judgment, the section of the judgment. So paragraph 33, the judge says the realities are in this case that all of these factors which I've mentioned mean that there is a safeguarding risk in this case over the next period of probably the short to medium term of the next 12 months or so. And the risk is going to be at its highest at the start and still significant until it's completed. So that's the timescale he had in mind.
Yes.
Which I think your submissions are different. You say the risk lasts until the youngest child is adult.
Well, I'm saying that it was unknown that it was going to be less than that because of the evidence that Professor Gray had said, and the sentence at the end of that sentence is and still significant until it was
completed. Yeah.
Was completed.
So if we were asking the judge if he was going to adjourn it to see how things worked out under the interim supervision order, then he'd be looking at a 12-month period.
Looking at the judgment, I see that's the judge's contemplation at that time. I see that. So, may I just turn briefly?
Yeah.
Thank you. If I may, just two further
Yes, certainly.
points. Firstly, in respect of the point about the risk to boys, whether it was the same, there were, of course, photographs of boys that were found. And
Well, that's why I'm asking the question.
Yes,
because I did
yeah,
taken
E124.
from what he'd said that
Yeah.
he was only interested in girls.
Yes. And electronic bundle reference. I'll just check it. I think it's 183.
I think he maintained that, but I think there was evidence.
There was evidence, yeah.
I think he maintained
Yes.
that he was only interested in girls, but I think there was evidence of both
Exactly.
that,
Yeah.
that Professor Gray refers to.
That's right.
Images.
Images. Exactly.
Thank you. But you need to take me to it.
And the other point is, my lady earlier this morning was asking about the involvement of the fathers, or the father. In terms of that, my instructions are that it isn't a consistent figure. That father is inconsistent with contact.
Is he the gentleman who's got health difficulties himself?
Yes.
So they may get in the way.
That's right. Yeah. And then and he didn't attend, for example. Then that would be new information potentially. But the social worker's understanding is that he'd wanted to distance himself effectively from the issues, or the word he'd used was the drama. And so, in terms of a possible additional protective factor, my submission is that isn't borne out by that gentleman, that father.
Not in the facts.
Not on the facts. On the facts of this case.
Yeah.
Thank you very much.
Ms. Lee, can I say for my part, and indeed my Lord's effectively said it as well, the degree of high level of professional competence of the social workers in this case is absolutely obvious, and the debate we're having is about the legal order that is put on the arrangement. And so often judges, if they comment on social workers, it's to be negative. Well, here I've certainly come away from reading these documents feeling this is our proper job, well done in their social work approach, and it's refreshing to hear the same social workers have been able to be involved in the case throughout, and so that's not sadly a given at all now. So I don't want there to be any doubt about the fact that all we're concerned about, and it's important, is the order,
Yes.
rather than anything that's gone in terms of preparation. The
May
judge-
I associate myself with that since you left me out?
I didn't deliberately leave you out. I didn't want to vote for you if you hadn't.
I think I'd made it clear by some question.
Very noted. Thank you very much. Unless I can assist further at this time.
No, thank you. Yes, Mrs.
May I just
Yeah.
clarify 2 points?
Yes.
I don't seek to make further submissions unless the court would be assisted by them. Their point I know because I was in the court below. First of all, it was suggested that there'd been judicial continuity. That's right from the issues resolution hearing to the final hearing. But just to be clear,
But it was
the case-
Judge Crowley when
Indeed.
the interim order.
That's right, my lord. I wanted to clarify that just for the purposes of your judgment. I don't say anything flows from it.
No.
And then, just in terms of the order of events and how they apply to ground 2, the chronology is as follows. So the report of Professor Gray became available on the 5th of October. The issues resolutions hearing was on the 12th of October. And that was prior to the final evidence of the local authority, or of course any party being available. At the issues resolution hearing, the local authority applied to adjourn and extend proceedings. This was supported by all of the other parties, and the local authority indicated then that if the parenting assessment and final evidence was to be filed within the current timescales of the proceedings, it would be a care order, whereas if proceedings would be extended, there'd be further time to assess. The final, after the adjournment was refused by the judge at first instance, the local authority evidence was then filed on the 24th of October. I hope that assists.
Yes. Well, certainly those behind us, Lee, will correct you if that's wrong. It seems to be.
Very grateful for that correction. Thank you.
There we are, unless I can assist any further.
No, thank you.
So I must announce we adjourn. You've got to prepare our judgment.
No.
Mr. Lorraine, we'll adjourn now, and plainly we'll deliver written judgments in this case. We'll endeavour to prepare them as quickly as possible, but inevitably that will be a week or two, if not more. We'll circulate the drafts on the usual basis, which is to encourage you to spot the inevitable, indeed the deliberate typographical errors that we put in there to keep you on your toes, but not encourage any further legal submissions or any other matter of substance. We don't anticipate that there'll be a need to anyone to attend on the event of handing down, and the order, this is a straightforward case, it will either be the appeal allowed or not, and if the appeal is allowed, the underlying order will be changed.
I'm grateful.
We're very grateful to both of you.
My lord indicated earlier that the court may be assisted by written submissions on the difference between...
Yes, I think we would be. Yes, they needn't be elaborate, and but just it's really just to point up the differences so that we don't inadvertently say something.
Indeed.
But what I wanted to do is to really make sure that we don't say something in this case where there's no point taken about the difference between the supervision and the care orders to the services, which is not the same in England because of some statutory difference. It may be that there's nothing in that point, so your submissions will be very short. Good. Thank you very much.
Goodbye.